Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I am your host, late, fashionably late or whatever, and certainly questioning. Nick Rekieta of Rekieta Law, a small law firm in central Minnesota, and my hair's all fluffy. I hate that. How's it going, guys? How's it going? Hope you are having a good day. I apologize for being late. I went on a run earlier, and then I was sitting down. And at my age, sitting down is the be-all, end-all of the entire day, right? If I sit down even once, I'm at risk of dying immediately and staying where I am because it is gloriously comfortable. So I do apologize for that. And then on my way to the office, kids, man, just flicking lights on and off. It's like, go to bed. Just go sleep. Just do that. Just do that. So anyway, how are you? I'm sorry to have missed you yesterday. We've got, some weird stuff going on in the world, and I was supposed to have a guest. That guest was Vox Day, and I must have failed in my communications to him. I thought that we were talking about doing the live show when I normally do a live show, and he must have been under the impression that we were doing it earlier in the day, which I respect his schedule. I misunderstood what was going on. So I take full responsibility for that miscommunication. I apologize for not having a guest or a show yesterday. I felt bad about it. But we did go ahead on Twitch and do the watch party, which is, a fun thing to do. But here's the deal. I didn't come on to do a show because I didn't have anything ready to go. It was going to be the interview, and then by the time I realized that the interview was not going to happen, Wednesdays are a busy day for me, and I was out most of it, and so I was out and unable to prepare an actual live stream for you guys, so I didn't want to just come on here and yak. I like to do that, but I didn't really have much. So we've got some things to talk about. We've got the Supreme Court. We've got some decisions that are out there that are really, really interesting decisions. They're very, very strange. And they're also not being reported on very well. So we're going to talk about those a little bit, not too in depth. We're not going to spend a ton of time on any of those decisions, but we'll clarify maybe a couple things on them. And then if any of them merit like a full breakdown, I may do that. I don't know. And then we've got the Flynn case, which is not a Supreme Court decision. That is an appellate level decision. And it's similarly interesting, and I'll just give you kind of my thoughts on it and how it's developing. There is an update today. The long and short of the Flynn update, just as a preview summary, is Judge Sullivan, he's the judge overseeing the criminal case that the government no longer wants to prosecute and is trying to just get out of it. Like, everybody now is like, we need to just go home. The government's saying that, the defense is saying that, and usually if you have those two in alignment, the judge is like, oh, good, peace, get out. I don't want to see you in my courtroom anyway. You're all ugly, and I hate lawyers. So that's how that normally kind of goes. But the judge is really holding on to this one. So then they appealed that, and the appellate court said, yeah, you should go ahead and probably just dismiss it, because if the government doesn't want to prosecute it, the judge can't make the government prosecute a criminal case. They can't force them to do that. The remedy, let me put it this way. Normally, when the government screws up in a prosecution, the remedy falls on the citizen, and the remedy is to go away from okay, the government screwed up and it's prejudiced your case, so you're free to go. You win, because we value that concept of innocent until proven guilty, and right to due process with rules. So when the guy who's coming after you and says, we're done going after them, the judge is like, no, go after him more. That's a complete 180 of how the system is supposed to work. And now he's trying to postpone it even longer. It doesn't make any sense. Doesn't make any sense. But that's where we're at there, and we'll get into it in a little bit. We'll get into that in a little bit and talk about it a little more in depth. And then, of course, we've got the Patreon lawsuit against its subscribers. And so we'll try and do this in 3 story arcs tonight. I'm not great at doing that. I tend to bounce around in my head. But the Patreon lawsuit against its subscribers involves tangentially, sort of, Vox Day and Owen Benjamin. And this is something I was going to talk to Vox about last night, but didn't really get to. And so, we're going to talk about that. And what we're going to do is, I think we're going to kind of go through the arguments on behalf of the customers of Patreon. And that'll give us, I'll give you the procedural background when we get there and what's led up to this. It is I'm not going to lie to you. This is a bizarre case. And procedurally, I have no idea how it should turn out. I know how I think it should turn out, based on sort of the common sense. Like, this seems unfair, so this is what the answer should be. I can tell you that really easily. I can tell you that right now. I think Patreon is entirely in the wrong in how they're doing this. And that's just, I'm sorry, that's just what you set up. That being said, there are some hiccups to that argument that might give Patreon a procedural or technical way out. They may be technically correct. And there's not a lot of law around that I'm aware of around how this should play out. It's the interplay between arbitration and courts, and when things become active, and these adhesion contracts and terms of service, and all of this mixing together into this, for lack of a better term, we have to use the legal, medical, scientific word, clusterfuck. That's what it is. And Mark Randazza is the lawyer representing the people, in the customers of Patreon. And he mentioned on Twitter that it is procedurally the most interesting case he thinks he's ever worked on. And I believe it. It just doesn't make sense. It's a web. And so we'll look at it, and I will try desperately to explain it and you have to come with me on this with the understanding that there might be a handful of lawyers in the country who would know this area of law off the top of their head. Maybe. And that's a stretch. It might just not have actually established law. Like, they might be making some new stuff, because it's also, this relies on new new regulations passed by the state of California in the past year. So it's, I'm going to tell you what I think about it, but I cannot profess to have any knowledge over what should be done here. It's all new ground. And so I'm going to defer a lot to the legal teams involved in their arguments. Mark Randazza has also graciously agreed to come on this show. I need to get with his scheduling people and find a day. I'm hoping next week. I don't know that he will talk about this case though. I don't like to you know, I'm not going to pressure any lawyer to talk about an existing case. I think Mark on the show will be a great guest. He's a champion of free speech. We've had an exchange on Twitter that was a little bit less than friendly, but that's okay, right? Like that's a fine thing. And I'm sure that will come up in the discussion. That's good. That's a good thing to talk through. And I want to talk to him about what it means to be, you know, regarded nationally as a champion of speech, what it means to defend the bad guys, how that reconciles with his personal moral compass or ethics. I think that'll be a great discussion. So we'll be talking about that as well. So that is kind of the layout of the show tonight. Tomorrow is the Chad Dad Chat. Larry, Doug, and Ty will be all talking about, you know, more of this. The last time we did the Chad Dad Chat was at the very beginning of COVID. Most states weren't locked down. So it's kind of going to be a little bit different, I suppose. We'll see, you know, how things are going through here. And I love doing the Chad Dad shows. They're not for everyone, but they should be. But it's just, it's a good time. Very, very wholesome content or whatever. Okay, next, let's get started. Shall we? Oh, and for those of you who are questioning, I believe we will do a watch party tonight, although it may only be one movie, and I'm not sure what it's going to be yet. And Berserker, we're going to talk about the Oklahoma decision, and what you just said is not what that decision says in any way. And so it's really important to realize how do I word this? How Supreme Court opinions are reported matters. And the phrasing of how they do it is really really important. The phrasing of how they report on it is really important. And these opinions nowadays are so dense. You go back to Marbury versus Madison. It's one of the most important decisions in history. It's like 5 pages. It's not that long. It might be longer than that, but it's really not that long. And now you've got these decisions coming out, and every decision is 70, 80, 90 pages. It's like, oh my God, court, stop talking. But yeah, we will be talking about that in our Supreme Court Roundup, which is going to start right now. But I'm going to go back just a little bit, and we're going to talk about this through a blog, Above the Law blog. This is what I'm talking about with that, on the vein of how it's reported is important. All right, so here's the Above the Law blog. In full disclosure, I think hold on, I gotta center this nicely, and I gotta, no margin on this. Oh, it's what we got here. This is the mobile version. I don't want that. Let's see if I can get rid of the mobile version. God, I just cannot get that much. Well, whatever. Above the Law is a terrible blog. This is a lawyer blog, and it is the people in it are ostensibly reporting as lawyers, but and they profess. I don't know that they profess, but it gives the idea of like an unbiased reporting, and it's not. They're very, very biased in how they come about issues. Their perspectives are uniformly left, and they are a mess. They are a mess. You will love the Army ad. How dare you? How dare you? Go Army. This was written by Tyler Broker, and Tyler is a well-published legal scholar of some capacity. I don't know if he practices. I don't know anything about this guy other than he has published law review articles in several publications, 3 or 4, which is a lot. For reference, the renowned constitutional scholar Barack Hussein Obama, blessed be his name, peace be upon him, has 0 published law review articles. And he is called a constitutional scholar. Therefore, Tyler Broker is an infinitely better constitutional scholar than Saddam Hussein Obama. Peace be upon him. May the prophet bless his name. So that to kind of set the stage. What that means. I'm not denigrating Tyler Broker's achievement in being published in law reviews. That's really a good thing. It takes a lot of work. It's a lot of dedication. However, his opinion on this is stupid. Let's just say that his opinion on this is stupid. But let me get. There's a couple super chats first that I want to get to right away. Patrick Law says rackets. Get on Sharp v. Murphy. Supreme Court is wilding out. Oh, okay. Also, you think Wade versus Myers case documents will be updated with what came out about the WhisperNet stuff? I have no idea. It depends on, I believe right now, I haven't talked to Meyer in a while, but I believe they're in discovery at this point and just going through their discovery schedule. And if you remember, their scheduling order has like discovery through most of this year and then their trial sometime in April of next year. So what comes out of discovery will be what they file with the court. And as of yet, I'm not aware of them filing anything with the court. So we'll see. Tonight I have an Oban 18 supper sandwich. Gadam Lou says, so how about the Supreme Court ruling that just ceded half of Oklahoma to the Native Americans, then it's not quite what they did. And again, I know it kind of seems like what they did, but we're going to take a look at and don't let me downplay the importance of their decision. The importance of their decision is pretty big. But that being said, it's being reported in a way that makes it seem big in a different way than it is. But we're gonna talk about that as we go. We'll get there. Fluffy Tet says, please explain the Oklahoma clusterfuck. Have seen takes like half of Oklahoma is now native land, to prior cases being overturned, to half of Oklahoma being under native law instead of state law. Seems like it's a disaster piece. It seems worse than it is, but it is bad in several ways, and not really bad, just a problem. Sakaki Onsai says the Sullivan-Flynn issue is easy if you look at it from the political aspect. Flynn knows where the bodies are buried, and while the case is going, he can't speak. Once it's dismissed, Hades is going to open for the deep state. I doubt it because Epstein. All right. Let's do this. So this article from Above the Law is about a decision that came out a couple days ago from the Supreme Court, and that is the Little Sisters of something, which is it's a religious organization, and it was a question about no, that was a different decision. My bad. The Little Sisters was a contraception decision, which the Supreme Court basically upheld their own decision from 2014, allowing a conscientious objection to businesses that have sincerely held religious beliefs, closely held businesses who have sincerely held religious beliefs, refusing to offer contraception as part of their healthcare if they so choose. And that was a Hobby Lobby decision back in 2014. They upheld it and clarified that the government couldn't impose upon them a paperwork requirement or an opt-out requirement that Obama tried to create after that 2014 decision. We're not going to get too in-depth into that case. It was correctly decided. It was a really easy issue because all of the Supreme Court's decisions on that issue have been decided in the same way, and there really wasn't any compelling reason to overturn it. And there's no reason that an organization should have to do some sort of crazy thing to prove to the government that they qualify to have an opinion. If you're going to let organizations have an opinion, then organizations get to have an opinion. And if you want healthcare that covers your vaginal pills, get a job at a place that offers it. Don't go trying to work for like a Catholic school and expect that the anti-contraceptive Catholics are going to fund your contraceptives at their nunnery. Like, that's just not going to happen. It's just not part of their belief system, and they shouldn't have to do anything to back that up. And really, it shouldn't be a mandate in the first place, but if your employer doesn't do that, it's not your job to force your employer to do that. Also, the overwhelming majority of contraceptives are basically free already. I don't know how else to say it. I'm pretty sure like generic birth control pills are $4 a month. So it's not that big, like, and that's without insurance. That's just at Walgreens or whatever. So what about my work? A hospital? It's run by a Catholic business. Yeah, lots of hospitals are. Because Catholic convents basically created the hospital system that we have come to be acclimated to. I don't know. It depends on the hospital, right? They can offer contraceptives. I don't know what your health plan covers or not. You'd have to check. So there's that. Okay. Mega cheap, $30 for a whole month in many respects. Yeah, I don't know. But either way, I mean, I know they're not bank breaking. Like, if you have basically any level of employment and you opt to go on to birth control pills for the purposes of contraception, you can probably afford it. But maybe not. Maybe not. This decision is actually Espinoza versus Montana. And this is a weird one. So Montana created a system, okay, where, and we'll read the article a little bit in a second so you get an idea. Shadows King, believe me, I know probably more than any of you are comfortable with about birth control, because we had fertility issues with our first couple kids, and when you're on fertility treatments, it requires lots of different types of birth control, and timing and all of that stuff, different medications. I actually am pretty well versed in it, and how much all of that can cost. So, so it's kind of, yeah, we finally got good at it though. That was great. It was like, it's like breaking the dam, right? Breaking the seal, whatever it is. Breaking the seal is when you pee after drinking a lot of beer and then you can't stop. You know, it's like that concept. You just had to get that first one out of the way. So, all right. Anyway, Espinoza versus Montana. Montana created a tax scheme in their tax code. And the scheme was you could basically get tax credit on your dollars that you put into a secondary education scholarship fund. And you could direct where that scholarship fund was going. So if you wanted to send people to private, is it second? I think it was secondary education. Maybe it was post. Yeah, I think it was K through 6. It doesn't matter. Private school. We'll say it's K through 12 or whatever. I don't remember if it's that. Yeah, I think it's that. It's not college. So private school tuition, because it's expensive to send kids to private school. So what you could do is you could pay that tuition as a scholarship and you get a tax credit for it. Dollar for dollar up to some amount. Like 17 grand or something. So that means you get reduced income, or I guess it was a credit back. Anyway, and the credit was paid out of the general fund of Montana. Okay, so the interesting thing was they set it up so you could direct it to whatever school, private school you wanted, but not a religious school. So you could support an atheist private school or a secular private school, but you could not support a Catholic school and get the tax credit, or a Mormon school and get a tax credit. So that creates this weird conflict, and the conflict is in the free exercise clause, because that says that you can't give money to a specific religious organization and get the same treatment that other similarly situated people do. Now, the Supreme Court said that was wrong. Supreme Court says you cannot exclude these religious schools, okay? Because if you're going to allow people a tax break to go ahead and you put money into this tuition fund, you get a tax credit for it. You should be able to give that to whatever private school you want. That's what the Supreme Court says. The above the law guy disagrees. And look at the hyperbolic nature of how he disagrees. Kyle says, living in Oklahoma, I know couples going through a divorce that will steal their spouse's car, park it at an Indian casino, and since it's tribal land, local authorities can't get involved. Process to get back causes headaches. Yeah. Yes. And that's now worse under the new ruling. So, okay. But here is how it's hyperbolically stated by above the law. Has 35 years of deterioration of establishment clause protection finally given the theocrats their victory? We'll go back to that in a second, but I need my face larger for you guys. Do any of you who might have any religion in you at all feel like the US is on the verge of a theocracy? Like, does anybody out there with abortion running roughshod over everything, does anyone out there think that religion is about to be the dominant voice in government? I mean, that's what the above the law guy is saying. The theocrats have now gotten their victory because in Montana, you get a tax credit to send a kid to a Christian school or a non-Christian school. That's what he's made this out of. So good job. Mithran Emra says yes, but only if we accept progressivism as a religion. And now that's a separate argument. I'm talking about the traditional religious thing. But yeah, I mean, in lots of ways, I would argue that we are on the brink of a theocracy. The problem is that we're not recognizing as a religion this ideology that is a religion. But here we go. Let's read through this real quick, because this is an interesting and stupid perspective. In a 5-4 decision in Espinoza versus Montana, the U.S. Supreme Court held that Montana could not exclude religious schools from a government subsidy program for private education. Court's reasoning in Espinoza is that denying the government aid to religious schools because of their religious character violates the First Amendment's free exercise clause. And it does. It absolutely does. The effect of the Espinoza decision, however, is that the other half of the First Amendment's guarantee of religious liberty, the Establishment Clause, has been stripped of its stated objective and protection. Now, let me take a moment and we'll argue, we'll take on this discussion, assuming arguendo that this guy's right. Tyler, as a constitutional scholar yourself, I'm sure you're aware that the Establishment Clause and the Free Exercise Clause are regarded as two sides of a tug of war or two sides of a balance. And therefore, holding one up will necessarily diminish the other. That's the idea. There's a conflict in the First Amendment about religion, and those two things are at odds with each other. They are always at odds with each other, and the Establishment Clause often trumps, for lack of a better word, the Free Exercise Clause, and vice versa. So even assuming arguendo that your argument wasn't idiotic, oh well, that's okay. The Free Exercise Clause on specific issues can and does win out over the Establishment Clause, and the Establishment Clause on specific issues can and does win out over the Free Exercise Clause. I mean, just think about this logically. If the state said, you don't have to go to church, you don't have to go to any particular church, but we want the state to give $1 million an hour to the Mormon church, well, that doesn't at all violate your Free Exercise Clause. That doesn't in any way hamper your ability to go to any church. However, it violates the Establishment Clause. And similarly, rejecting that under the Establishment Clause doesn't nullify the fact that the Free Exercise Clause exists. What if you trying to think of another analogy? The way it works out is those two things are two separate things, and they're in tension. So sometimes they will come into a balancing test, and the court has to determine which one wins. In this case, free exercise is more important than establishment, because in no way ever does giving a tax credit to someone who pays private school tuition to a religious school in any way establish a religion. Are we clear on that? Like, the Catholic Church does not exist because the state gave a tax credit to someone who sent their kid to a Catholic school. That's not how it's going to work. That's not the state funding it. That's not anything to do with the establishment of a religion at all. So, in plain language, the Establishment Clause prohibits the government from enacting law quote, respecting an establishment of religion. As to what respecting an establishment means, in Everson versus Board of Education versus Ewing, or Board of Education of Ewing, the Supreme Court recognized that the provisions of the First Amendment had the same objective and were intended to provide the same protection against governmental intrusion on religious liberty as the Virginia Statute for religious freedom. Now, the Virginia Statute for religious freedom, this is a thing that lawyers do when they try to make one thing that is unlike the other thing seem like the other thing. All right? So, the Virginia Statute for religious freedom was passed in something like 1786 in Virginia. Thomas Jefferson proposed it, but then he was over in France. James Madison got it through. Now, what the Virginia statute was designed to do was, as you may or may not know, at the founding of the nation, 1776, every single state had a state-mandated religion except, I think, Rhode Island. So, that being said, Virginia had a state religion as well. And the Virginia, they attempted to pass a law in Virginia that does this. That said, we're going to tax you. Specifically, and remember, in 1786, there was no income tax. All the taxes were sales and property taxes. Okay? So there is no income tax. And they said, we're going to impose a tax on every person. And with that money, we are going to give money to whatever specifically religious institution you choose. Okay? So that was the idea. So there is no tax that exists for this thing. Now they're going to tax and give money to whatever institution the tax person chooses. It's a forced tithe, is what it is. Tithe through taxation. And it couldn't go to a non-religious institution. And the idea was that, okay, we're not going to have a state religion anymore. However, Virginia had a state religion up until that point. So the idea is pretty simple. Where is the overwhelming majority of money going to go? The state is going to impose a tax, and then almost all of that tax is going to be funneled directly into the coffers of the predominant church. I don't remember what it was. It might say in here in a second, but that was the idea. Again, this in no way reflects the law at issue in Montana. In no way at all does a tax credit for your choice, not mandated, no one has to do this, for your choice to send a kid to any college or any private school, and again, doesn't have to be a religious-based school or anything, any private school, you can choose to send and you will get a tax credit. That's it. So this guy is trying to make this law look like the Virginia law that was defeated by the Virginia Statute for religious freedom. And that is the dumbest argument I can think of. In his infamous work explaining and defending religious liberty in Virginia, James Madison stated that to grant churches access to government funds was a contradiction to religion itself, as, quote, every page of it disavows a dependence on the powers of this world. Civil support for religion also represented a contradiction in terms because it weakened those who profess this religion a pious confidence in its innate excellence and the patronage of its author. Okay. Later on, as president, Madison was explicitly clear that the appropriation of funds of the United States for the use and support of religious societies stood contrary to the article of the Constitution which declares that Congress should make no law respecting a religious establishment. So there you go. That's Madison's view. By the way, Madison, his biblical interpretation of state involvement with religion is, I'm going to say it's a little bit ill-founded, but, you know. But do religious schools claim that income and get taxed? Religious schools don't get taxed. Actually, I don't believe most private schools don't get taxed. Okay, the idea that the First Amendment's religious liberty provisions, which the court has said are derived directly from the Virginia statute, would be violated by denying churches access to government funds contradicts a stated tenet of the liberty itself. But that contradiction is precisely what the Roberts Court upheld in Espinoza. It actually doesn't. It doesn't. And again, what they're doing here is conflating the idea of a religion, a particular state religion, an established religion, versus any and all religions plus non-religions. You have to remember that in Montana, under this law, every single organization is treated equally. All educational organizations are treated the same by whether they're religious or not. Now that the Supreme Court has said this is wrong. Prior to that, the only education organizations that were treated differently and worse were religious schools. There was an inequality, and now there is an equality. That is what's going on here. This guy is actually arguing for inequality. It doesn't matter if it's a Jewish school, a Muslim school, a Hindu school, or a Catholic school. Whatever school you want, you can use now that the Supreme Court has said that was wrong, you can now get the same tax credit. And no one is obligated to pay to any school of any kind. Anyway, I don't want to spend too much time on this article because it's really stupid. In Espinoza, Chief Justice John Roberts dismissed Establishment Clause concerns by pointing to over 3 decades of precedent where the court has upheld the distribution of government funds to religious organizations when, quote, the link between government and religion is attenuated by private choices. Yeah. So if the government is going to give out funds to a category and someone says, well, I want to direct my portion of those funds to this thing, and it happens to be religious, the government doesn't get to say, well, no. And we don't want them to. We don't want them to at all. That's a terrible thing to have them do. Now, if you want to argue all sorts of stuff about, like, should churches be tax exempt? My opinion is no. I don't think any organization at all should be tax exempt. No organizations. I don't think there should be nonprofit charities. I don't think any of that should exist. But they do exist. And so as long as you're giving out charity status to anybody, I don't see why religion should be excluded. So, and until someone comes up with a good reason why we should have tax exempt charities, but they shouldn't be religion, I'm going to stick with my interpretation of that. Okay. To use an analogy from the court's precedent, a state may issue a paycheck to one of its employees who may then donate all or part of that paycheck to a religious institution, all without constitutional barrier. And that's a good point, right? State and federal employees can take all of the money that they get and they can donate it tax exempt and tax deductible to a religious institution. We allow that because that's a personal choice to do so. The fundamental structure of the Montana program, however, makes this analogy appear inapt to the one at issue in Espinoza. To understand why, we have to get into some background on the Montana tax program, and then I'll read just about the tax program, and then we'll move on to the next Supreme Court issue. Ryan English, how do you tax churches and not bring them under the big iron boot of the state? Because if if you simplify the tax code and apply it evenly across everything, then everyone is equally under the big iron boot of the state. And no one is more under it than anyone else. We don't have that system, and we're a long way from it. So I have no illusion that it's going to happen. But my ideal situation says that no organization of any kind is exempt from taxes, and all taxes are flat and fair. That's it. Like I said, we'll never get there, so I don't have to worry about defending it too much. As detailed by the Montana Supreme Court, the program offers the taxpayer a dollar-for-dollar tax credit, utilizing money from the common tax pool to be used for tuition scholarships to private schools. In other words, the program at issue in Espinoza involves government compelling all residents through taxation to financially support a certain type of service, private education, which after the Espinoza decision must now include religious education for anyone who wants it. And this is where they lose me. Because if the argument is the Montana system should not be allowed to compel any tax funds as a credit towards a private choice to a private institution for private education, I agree. Why on earth should tuition to one of these tuition scholarships, why should that exist at all? I don't think it should. However, does the Montana legislature have the power to levy a tax for a specific purpose that they believe to be for the common good of a state-provided service, which is or a state-provided area, which is education? The state is dominant in education in every single one of the 50 states. No, there is no homeschool state which has tipped that scale. So of course Montana can levy taxes on its people through its legislative body and then fund private education in a way they're already doing it for public education. There's a fly in my office. I hate it. So of course they can do that. Should they? Well, no. No, you should hang all of your legislators or whatever. That's a terrible law. You shouldn't do it. But they can. They can create tax exemptions in Montana tax code. It's not federal. Doesn't affect anybody outside of Montana. It's literally their entire represented body in Montana is responsible for its constituents, and that's who made that choice. You should vote all of them out, and then, like I said, there's plenty of tar and feathers to go around. But now they're going to argue that once they've decided to do that, that you can't choose a religious school, and I think that's ridiculous. But the type of service government can compel you to fund through taxation matters, or at least should, precisely because we have an establishment clause. What? But the type of service government can compel you to fund through taxation matters, or at least it should, is what it means, precisely because we have an establishment clause. No. I mean, sort of, but no, not really. You're funding private education. It just so happens that there are religious organizations that do private education. It's not the sole purview of religious organizations. It's not even the primary focus of them. Think about it. When the government pays someone to be an accountant or a groundskeeper or a legislator, my taxes are being compelled to pay for those secular services. It is true. But it is also self-evident that paying for these secular services is where the government compulsion ends. In the program at issue in Espinoza, however, the service government is compelling must now include religious education. Yeah. It must. Get over it. By mandating that the government must now provide religious education. No, that's not actually what it mandates. That's not what it mandates at all. And see, this is where the hiccup is. Because it doesn't mandate government provide a religious education. Government has no mandate to provide private education. Government chose to give a tax credit for private education. That's what they picked. once government chose to do that, that's not a government mandate. We're now out of the Establishment Clause because this is not a necessary function of government to fund private education in any way. And it doesn't entirely fund private education, only people who set up these tuition scholarships. That's it. Let's see. By mandating that the government must now provide religious education, any attenuation between government and religion evaporates? No, because if every single person in Montana who did this did it to a non-religious institution, there's no mandate by government to include a religious institution. It's entirely attenuated by that private choice. Or if no funding occurs at all to any institution. Now, what broker here is a broker? What he's scared of is the fact that lots of people in Montana will choose private religious schools. Lots of them will. Moreover, the fact that government is allowing private actors to direct the funding does not make the government compulsion for funding the services any less significant when it occurs. No, you idiot! It literally does! It literally does. That's actually what you said a couple paragraphs earlier when you quoted the Supreme Court saying that it actually does. That attenuation of private choice is what matters. It is what makes the significant, makes it less significant. That's actually the one thing that does matter here. At least according to a Madisonian Virginia statute standard and also recent Roberts Court precedent. So now, real quick, let's skip this next paragraph because his assessment of Virginia and Madison is flatly idiotic. It again requires you to forget all of the surrounding context of what Virginia and the United States looked like in 1786. But here we go. Here's his recent court precedents. Are you ready for this? Even if you want to dismiss the historical reasoning, however, the fact is that just 2 years ago, a majority of the court in Janus versus Asks Me rejected a remarkably similar attenuated private choice justification used in Espinoza. No, it didn't. Is anybody familiar with what Ask Me is? He's now going to argue that unions are the same somehow as religion, even though unions are not afforded any sort of free exercise or establishment specifically in the Constitution, however, are given loads more protection in several instances. But in Janus, they basically said the state couldn't force you to fund unions. Even more frustrating, the reasoning by the court in Janus was based on a Madisonian Virginia statute framework. In Janus, the court held that forcing free and independent individuals to endorse ideas they find objectionable raises serious First Amendment concerns. Yes, by using the power of the state to compel an extraction of money from your paycheck in the form of union dues, who specifically lobby against your political speech, is very, very different. It's very, very different than giving someone a tax credit if they choose to fund a private school tuition. I can't stress enough. This is a terrible comparison. Terrible comparison. That includes compelling a person to subsidize the speech of other private speakers. Do you see the problem here? No, you do, because you need a helmet to walk down the street. But nevertheless allows you to be, the notion that the First Amendment guarantees against the state forcing you to subsidize speech of the private speakers but nevertheless allows you to be forced to subsidize the religion of private citizens. It's not what you're doing. That's the interesting thing. That's not what you're doing. Is grossly illogical, but that is the First Amendment standard we are left with after Espinoza. No, you are dumb, Mr. This is him, apparently. Tyler Broker. His work has been published in the Gonzaga Law Review, the Albany Law Review, and is forthcoming in the University of Memphis Law Review. Feel free to email him or follow him on Twitter to discuss his column. No. That would be arguing with a dummy, and I don't want to do that. I don't want to do that at all. But the fact remains that the guy's comparisons just don't jive with reality. Okay. Gelth Walker says, Nick, get that bloody grandma wig off your head. It doesn't suit you. Rude. I went for a run and took a shower, and I'm left with floofy, puffy hair because I didn't want to put gel in it before going to bed. What I miss? Only just joined. Sorry, I was busy. You didn't miss much. Just me yelling at stuff. And then Stega says, was told to stay home from work for 2 weeks today as a coworker I had close contact with tested positive for the coof. Not worried about it myself, but here's my first ever $20 super chat to celebrate my 2-week paid vacation. And all you did was be next to someone. Fantastically done. I'm glad you got a paid vacation out of the deal, and I hope you enjoy it. And thank you very much for your first super chat. Please don't die from the coof. Yeah, because we don't want you dying from the coof. Don't even get it. Make them feel real stupid by paying for you to have a healthy 2-week education. Vacation. Okay. On to the next topic. What is the next topic from the Supreme Court? We have, let's talk Oklahoma. Okay, so let me get the Supreme Court. McGirt versus Oklahoma. Again, this is an 86-page document. We are not going to read an 86-page document. We're going to go through the syllabus of it and see the major holdings of it, and see what we can distill as far as truth out of that, rather than relying on sensationalist headlines. Okay. So McGirt versus Oklahoma. Right away, we can see that this is going to be limited in scope to criminal acts. I hate the fly. The Major Crimes Act provides that within the Indian country, oh no, cancel the Supreme Court, any Indian who commits certain enumerated offenses shall be subject to the same law and penalties as all other persons committing any of those offenses within the exclusive jurisdiction of the United States. Okay. So right there, the Major Crimes Act says that Indians in Indian land are subject to the jurisdiction of the United States, which means they're sovereign from their state governments, in the way that federal agents are sovereign from state action. In the course of their federal duties. Not if a federal agent goes out and just murders someone, they're not immune to state action. But if they're in the scope of their federal duties, and federal employees don't pay state income tax, for example, for similar reasons. Indian country includes, quote, all land within the limits of any Indian reservation under the jurisdiction of the U.S. government. Petitioner Jimmy McGirt was convicted by an Oklahoma state court of 3 serious sexual offenses. I think he's 70-something years old and raped like a 4-year-old. Let's be very clear about Jimcy McGirt. Jimcy McGirt should be put on a wall, and run into with a bulldozer. Fuck him. Terrible human being. Absolute atrocity being committed, and he deserves whatever bad thing comes his way. He unsuccessfully argued in state post-conviction proceedings, so he was tried and found guilty by the state. That the state lacked jurisdiction to prosecute him because he is an enrolled member of the Seminole Nation and his crimes took place on the Creek Reservation. He seeks a new trial, which he contends must take place in federal court. And oh my, do I hope they bring it in federal court. Oh boy. I hope they bring it. Bring it to him. Held for Major Crimes Act purposes. This is an important thing being withheld from much of the popular analysis you've seen on Twitter and other places. Land reserved for the Creek Nation since the 19th century remains Indian country. For Major Crimes Act purposes. Not for other purposes. The Supreme Court did not annex a portion of Oklahoma and provide it to the Injuns to chase down the Buffalo Bills or whatever. None of that has happened. This is only, and this is limited to the Major Crimes Act. Congress established a reservation for the Creek Nation. An 1833 treaty fixed borders for a permanent home to the whole Creek Nation of Indians and promised that the United States would grant a patent in fee simple to the Creek Nation of Indians for the assigned land to continue so long as they shall exist as a nation. Fee simple means that there is no restriction on the real property. So it is not restricted by federal government easements or anything like that. They own that chunk in fee simple. Now they can grant easements, they can do all of that, but anything, that would all be anything they've done after 1833 of their own volition on reservation land. Now they may have some easements to allow highways and stuff like that in, but those easements don't constitute jurisdiction necessarily by the state government unless they create it, or importantly, the Congress of Oklahoma creates those exceptions. Because the Oklahoma Congress can pare this back. They just haven't done it in regards to the Major Crimes Act. To continue so long as they shall exist as a nation and continue to occupy the country hereby assigned to them. The patent formally issued in 1852. Though the early treaties did not refer to the Creek lands as a reservation, similar language in treaties from the same era has been held sufficient to create a reservation. C.e.g. the Menominee Tribe versus United States, and later acts of Congress referring to the Creek Reservation leave no room for doubt. In addition, an 1856 treaty promised that no portion of Creek lands would ever be embraced or included within or annexed to any territory or state, and that the Creeks would have the unrestricted right of self-government with full jurisdiction over enrolled tribe members and their property. Congress has since broken more than a few promises to the tribe. Nevertheless, the Creek Reservation persists today. Okay. 1. Once a federal reservation is established, only Congress can diminish or de-establish it. Doing so requires a clear expression of congressional intent. 2. Oklahoma claims that Congress ended the Creek Reservation during the so-called allotment era, a period when Congress sought to pressure many tribes to abandon their communal lifestyles and parcel their lands into smaller lots owned by individual tribe members. Missing from the allotment era agreement with the Creek, however, is any statute evincing anything like the present and total surrender of all tribal interests in the affected lands. And this court has already rejected the argument that allotments automatically ended reservations. Oklahoma points to other ways Congress intruded on the Creek's promised right to self-governance during the allotment era, including abolishing the Creek's tribal courts and requiring presidential approval for certain tribal ordinances, but these laws fall short of eliminating all tribal interests in the contested lands. Oklahoma ultimately claims that historical practice and demographics are enough by themselves to prove disestablishment. This court has consulted contemporaneous usages, customs, and practices to the extent they shed light on the meaning of ambiguous statutory terms, but Oklahoma points to no ambiguous language in any of the relevant statutes that could plausibly be read as an act of secession. Such extra-textual considerations are of limited interpretive value and the least compelling form of evidence. In the end, Oklahoma resorts to the state's long historical practice of prosecuting Indians in state court. This is the problem. This is the problem. Prosecuting Indians in state court for serious crimes on the contested lands, various statements made during the allotment era, and the speedy and persistent movement of white settlers into the area, but these supply little help with the law's meaning and much potential for mischief. The problem with this ruling is there are a lot, which means more than zero. When we're talking about personal liberty, more than zero is a lot. There are a lot of people who have been prosecuted wrongfully by the state of Oklahoma. They have been rightfully found guilty of their crimes and put into prison wrongfully because the state of Oklahoma didn't have a way to do the prosecution. They didn't have the authority to do so. I say rightfully convicted of their crimes because they, in essence, received a fair trial. As we understand it, outside of specific cases, they would receive a fair trial in the state court, just like anybody else would. However, the state court shouldn't have had the power to do it. So now you have people potentially sitting in jail for very serious crimes with who are now going to be talking to lawyers. Because now they go, wait a minute. I was convicted in state court. I didn't get my fair trial. I want a mistrial. I want a retrial. And many of them may get that, and they may have the opportunity for the feds to recharge them, but due to any number of circumstances, destruction or deterioration of evidence, lack of severity of the crime, lack of judicial resources, the feds may not want to prosecute any or all of them. It's hard to say. Okay. In the alternative, Oklahoma contends that Congress never established a reservation, but instead created a dependent Indian community. Told that the Creek Nation, the Creek, never had a reservation, would require willful blindness to the statutory language and a belief that the land patent the Creek received somehow made their tribal sovereignty easier to divest. Congress established a reservation, not a dependent Indian community for the Creek Nation. Even assuming the Creek Nation is even assuming that the Creek land is a reservation, Oklahoma argues that the Major Crimes Act has never applied in eastern Oklahoma. Claims that the Oklahoma Enabling Act, which transferred all non-federal cases pending in the territorial courts to Oklahoma state courts, made the state's courts the successors to the federal territorial courts' sweeping authority to try Indians for crimes committed on reservations. That argument, however, rests on state prosecutorial practices that defy the MCA rather than on the law's plain terms. Finally, Oklahoma warns of the potential consequences that will follow a ruling against it, such as unsettling an untold number of convictions and frustrating the state's ability to prosecute crimes in the future. This court is aware of the potential for cost and conflict around jurisdictional boundaries, but Oklahoma and its tribes have proven time and again that they can work successfully together as partners, and Congress remains free to supplement its statutory directions about the lands in question at any time. So, that is the opinion. It's Ginsburg, Breyer, Sotomayor, Kagan, joined. It was written by Gorsuch. So Gorsuch was the swing vote. Roberts filed a dissenting opinion in which Alito and Kavanaugh joined, in which Thomas joined except as to footnote 9. Thomas filed a dissenting opinion as well. And we're not going to read through them because we're not reading through the opinion. This is just the summary of the opinion. Reading through the opinion would make me want to die and would be too long for this live stream. That being said, This is, Roberts is not flipping on this one. This is Gorsuch. And I think, unfortunately, that this is the right decision. This is the right decision to make. Like, Oklahoma has been improperly prosecuting people against federal law. I'm sorry that they've done that and they've done it for so long. They shouldn't be doing that. Now, of course, this decision involves the most heinous of crimes you can imagine, right? And that makes it particularly bad. But if this were like the state doing a drug bust or something, I don't care. I only care because of how bad the crime is. And it is going to be a mess for them to work out. They should go ahead and fix that mess as soon as possible. They really should. And also, Eagle Loan mentioned it earlier, but I don't believe that reservations should be a valid exercise of anything. I don't believe that we should have miniature sovereign nations that are within our federal and state borders. I think those are problems. And I think that people should be off of reservations and assimilate into greater society, because I don't think it's beneficial to have insular governmental communities inside the borders of a state. To me, that doesn't seem like a good policy. So, but I want the casinos. I want casinos to exist. Anyway, so that is McGirt. That's the Oklahoma decision that a lot of people have questions on. So I wanted to go through it. A lot of people were talking about it, and I may do a short video about it. I don't know. I don't know what people actually care about in the Supreme Court stuff. The next one we're going to talk about is Trump versus Mazars, USA. And then there's Trump versus Vance. No, wait. Trump versus Vance is the more important one. And then Trump versus Mazars is interesting, but it's more of like a mitigating decision. All right. So this is the case, if you're not aware, of Donald Trump his financial records have been subpoenaed. Mazars LLP is his accountant, and they are a grand jury in New York has gone ahead and sent a subpoena ducis tecum to his accountant for his financial records relating to his personal and business interests. And Trump does not want his personal financial and business financial information to be public. He doesn't want that, as many of us would not. And the real question is, what do they need them for? Right? Now, I want to clarify something at the onset, because I think some people who've seen this ruling may be confused. This ruling does not mean that the grand jury or the district attorney of New York get Trump's financial records. It does not. This was the first asserted defense of the Trump campaign in this matter. And it went all the way to the Supreme Court. It was brought, this was requested back in 2019. And it went to the Supreme Court. Trump now has several other defenses still at his disposal to go ahead and resist the subpoena. What he tried to do was get this issue to be the deciding factor in resisting the subpoena, saying that the president had immunity from state subpoenas. And the Supreme Court says, no, president does not have immunity for non-official communications in state subpoenas, and complying with the state subpoena is not so overly burdensome on the President of the United States to render him unable, by distraction, to deal with his day-to-day duties as executive in chief. That's the summary of the court's ruling. And we'll again, we're going to read the syllabus and talk about it. But this just means that the president does not have unquestioned immunity from a state court, criminal court subpoena. And he, by the way, definitely doesn't have it from a federal subpoena, as we will read going forward. All right. So this is not actually, this is only new law because no state prosecutor has ever subpoenaed, as far as the Supreme Court knows, and I'm guessing their researchers are pretty good. As far as the Supreme Court knows, no state prosecutor has ever attempted to subpoena a sitting president in a criminal matter, ever. So here we go. Trump versus Vance, District Attorney of the County of New York. In 2019, New York County District Attorney's Office, acting on behalf of a grand jury, served a subpoena ducis tecum on Mazars USA LLP, the personal accounting firm of President Donald J. Trump, for financial records relating to the president and his businesses. AGK says, you don't want casinos. I'm a slot technician. Those things are just attacks on hope. Oh man, I don't trust slot machines at all. And I barely trust casinos, but I believe that everyone has the freedom to go and waste their time and money. That's what I believe. You know, like I want legal heroin at some point, not because I do heroin, but because I just think people should have that, eventually should have that right to ruin their own lives. Also, because Scott Weiland unquestionably made better music while on heroin than off. R.I.P. Scott Weiland. Oh, and Troll with a Purpose says, oh no, Nick for loot crates. Yes, I am pro loot crate existing and not being regulated by the government. I think it should be regulated by us. I think we should all be saying, if you keep making loot crates, we will burn down your building. Jay Venom, no, I get it. And I agree with you. I disagree with myself right now. Like, I'm not saying that heroin should be legal tomorrow. I think we should get to a point where people have the ability to destroy their own lives and choose not to. You know, same way, right? Not quite the same, but in similar ways. All right. The president, acting in his personal capacity, sued the district attorney in Mazars in federal district court to enjoin enforcement of the subpoena, arguing that a sitting president enjoys absolute immunity from state criminal process under Article 2 and the Supremacy Clause. I don't think so under Article 2. I think the Supremacy Clause argument was better, but, you know, Supreme Court says no to both. The district court dismissed the case under the abstention doctrine of Younger versus Harris, and in the alternative held that the president was not entitled to injunctive relief. The Second Circuit rejected the district court's dismissal under Younger, but agreed with the court's denial of injunctive relief. So the district court says, we don't even have jurisdiction on this, bro. And then the Second Circuit Court of Appeals said, no, you did have jurisdiction on it. But it didn't matter because in the alternative, the district court did offer an opinion saying that the president was not entitled to enjoin them under absolute, absolute immunity. Concluding that presidential immunity did not bar enforcement of the subpoena and rejecting the argument of the United States as amicus curiae that a state grand jury subpoena seeking the president's documents must satisfy a heightened showing of need. So the Solicitor General of the United States sent in an amicus curiae brief, which is a friend of the court brief. It means a non-party gets to submit a brief to the appeals court and ask some questions or bring up some things that may not have been fully briefed by the parties. In this case, the Solicitor General of the United States, who I believe is resigning, and maybe because of this, who is resigning, stepped in and wrote a brief and argued that in the absence of a complete immunity, that a state subpoena should be required to have a heightened level of security, a heightened showing of need. The Supreme Court disagrees on this. Held. Article 2 and the Supremacy Clause do not categorically preclude or require a heightened standard for the issuance of a state criminal subpoena to a sitting president. Now, again, the interesting thing is here is it is long believed that a sitting president is immune from a state or federal prosecution. That if the president is the target during the presidency, they must wait to actually indict a president. That's not actually been decided by the courts. We don't know if a sitting president is immune in that way. But that's the belief. The belief is that basically that the president could pardon himself if necessary, so you don't bother. It would also distract from his role as president, and the impeachment process exists as a check on that. So if you want to criminally prosecute a sitting president, you may as well impeach them first. And then after that impeachment, you charge them criminally for whatever they did within the statute of limitations, similar to everybody else. Okay, in 1807, John Marshall, presiding as Circuit Justice for Virginia over the treason trial of Aaron Burr, granted Burr's motion for a subpoena ducis tecum directed at President Jefferson. In rejecting the prosecution's argument that a president was not subject to such subpoena, Marshall held that a president does not stand exempt from the Sixth Amendment's guarantee that the accused have compulsory process for obtaining witnesses for their defense. Now, this is an interesting concept, right? Because this is the precedent that's out there. Who is the accused in this case? I don't think there is an accused in this case. They haven't actually filed criminal charges on anyone. And to me, that is part of the problem, and actually what may be ultimately part of the defense for Trump's rejection of this subpoena. You know what? Talk to me when you actually file something, you idiot. You dumb person. You terrible, terrible prosecutor. Worst prosecuting I've ever seen. I've seen much better prosecutors outside in greater areas of New York. Much better ones. I'm not aware of any actual defendant in this case. And so therefore, it's not a defendant. So the Aaron Burr was charged with treason and the murder of Alexander Hamilton. And in that trial, he is then requesting a subpoena for President Jefferson for whatever, some documents Jefferson may have had to exonerate Aaron Burr. Who knows? I don't know I'm sure somebody does. I'm not familiar enough with that case. It's probably a fascinating trial to go through, but I'm not familiar with it. He's looking for assistance with his defense. Trump is different. There is no defendant. No private individual is going, hey, I need to see Trump's financial records to prove I didn't commit a crime. And I think that may be his defense. And that's what may end up getting him out of having to produce these documents in the long run. That's US v. Burr. The sole argument for an exemption was that a president's, quote, duties as chief magistrate demand his whole time for national objects. But in Marshall's assessment, those duties were not unremitting, and any conflict could be addressed by the court upon return of the subpoena. So basically, turn over the documents, and then the court will deal with the documents. Marshall also concluded that the Sixth Amendment's guarantee extended to the production of papers. The propriety of introducing any papers, he explained, would depend on the character of the paper, not the character of the person who holds it, and would have due consideration upon the return of the subpoena. Jefferson agreed to furnish whatever justice required, subject to the prerogative that to decide whether particular executive communication should be withheld. So Jefferson says, yeah, no problem. You can have my personal papers, but anything that is an official communication, I may have to exercise executive privilege over. Okay. In the 2 centuries since Burr, successive presidents from Monroe to Clinton have accepted Marshall's ruling that the chief executive is subject to subpoena, have uniformly agreed to testify when called in criminal proceedings. In 1974, the question whether to compel the disclosure of official communications over the president's objection came to a head when the Watergate special prosecutor secured a subpoena ducis tecum, directing President Nixon to produce, among other things, tape recordings of Oval Office meetings. This court rejected Nixon's claim of an absolute privilege of confidentiality for all presidential communications, recognizing that compulsory process was imperative for both the prosecution and the defense. The court held that the president's generalized assertion of privilege must yield to that demonstrated specific need for evidence in a pending criminal trial. And again, demonstrated specific need for evidence in a pending criminal trial is actually not at issue here, to my knowledge. President Nixon dutifully released the tapes. This history all involved federal criminal proceedings. Here, the president claims that the Supremacy Clause gives the sitting president absolute immunity from state criminal subpoenas because compliance with such subpoenas would categorically impair the performance of his Article 2 functions. This is what I was talking about with the Supremacy Clause. Actually, I agree with this. If every state decided to have a district attorney prosecute someone and decide that something that the president had was necessary for the prosecution, they could send subpoenas to the president all day. And responding to state subpoenas as a chief executive of the federal branch of government, of the federal executive branch, that, in my opinion, does violate the Supremacy Clause. Supremacy Clause is that federal statutes outweigh, or federal government sometimes trumps state government when their laws are directly in conflict. For lack of an easier way to say it. And I agree with this argument. The Supreme Court does not agree. Because compliance with such subpoenas would categorically impair the performance of his Article 2 functions. Solicitor General, arguing on behalf of the U.S., claims a state grand jury subpoena for a sitting president's personal records must at the very least meet a heightened standard of need. President's unique duties, blah, 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 blah. We're not going to go through all this. Basically, they say, look, he's been subject to federal subpoenas for 200 years. We don't understand how a state subpoena would be overly burdensome. But let me help you. There are 50 states. That's 50 possible state subpoenas. There are any number of municipalities and counties within states with prosecutors who could be deciding that they need the president's papers. And it could get to a point of ridiculousness where the president is, even if they're all frivolous, is defending against several subpoenas. I mean, just imagine if every court in a particular state sent a subpoena to the president that he was then required under this ruling to comply with. That gets pretty burdensome, and it may take the president's time and attention away from other duties. That's the argument that they're making, and they disagree with that. So the president contends that complying with state criminal subpoenas would necessarily distract the chief executive from his duties. Grounds that concern on Nixon v. Fitzgerald, which recognize the president's absolute immunity from damages liability predicated on his official acts. That has nothing to do with it. Yeah, and the court rejected immunity based on distraction alone in Clinton v. Jones, where Star Jones sued President Clinton, and he tried to say, "I'm just too busy. Look, I'm just too busy as president to deal with that bitch's problems." The Supreme Court said, no, you do have to deal with that, and you can do that and still do your duties. But that's a little bit different to me. That's, again, a civil case directly involving the president of the United States for liability from before the time he was a president. He should have to answer for that. This is different, of course, in that it is a federal grand jury with no criminal prosecution yet subpoenaing the president's documents. For what? Can't figure that out. President claims this case is different. I agree. Stigma being subpoenaed will undermine his perception. I don't care about that. Subjecting presidents to state criminal subpoenas will make them easily identifiable targets for harassment. I agree here. But the court rejected a nearly identical argument in Clinton, concluding that the risk posed by harassing civil litigation was not serious because federal courts have the tools to deter and dismiss vexatious lawsuits. Here's the problem with this. It's easy for a court to dismiss civil lawsuits and punish civil litigants. They can do sanctions, they can have attorney's fees, they can do all sorts of stuff against a vexatious civil litigant. Civic or criminal litigation against a president, the court does not have the same tools to punish overzealous prosecutors. This is very, very different. A prosecutor can vexatiously bring charges against someone all day if they have any grounds to do so, and you can't stop them. Similarly, they can apparently just issue subpoenas all the time if they can get a grand jury to agree that they need one. And that's a mess. All right, so long story short, there's no heightened standard. There's no immunity from it. And we're not going to read the opinion. That's the end of the syllabus. The answer is now it goes back to the district court, and then Trump will argue on the basis that anybody else who's resisting a subpoena would argue. Privacy, relevance. Like, how am I relevant? What is the specific need that you have for this subpoena? How do I get to weigh the validity of the evidence? How do we get a court to weigh the validity of the evidence without an actual charge being involved? He gets to go and argue all of that. And how those arguments will go, we'll see. I think the most important thing for Trump is those arguments will likely take longer than November. And that's really what he's after. That's really what he's after. Make it take longer than November. Okay, so that's the Supreme Court roundup, the Supreme Court wrestling or whatever. That's a mess. Okay. Flynn Sullivan. Let's pull up this Sullivan case. Judge Emmett Sullivan. Here's the Flynn case next. Hope you guys are ready for some Flynn issues. End of the story, Democrats are going to find out Trump is rich. The more interesting thing would be to find out Trump is poor. In my opinion. It's okay, so Judge Emmett Sullivan contests D.C. Circuit decision ordering dismissal of the Flynn's case. Quote, the panel's decision threatens to turn ordinary judicial process upside down, says veteran trial lawyer Beth Wilkinson, representing U.S. District Judge Emmett Sullivan, said in Thursday's petition for a full court rehearing. Okay, so this is something that has happened. Emmett Sullivan did appeal this. He did appeal this case. No, sorry. Flynn appealed Sullivan's continuing of the trial, and then Sullivan hired a former judge to make the arguments as an attorney that this case should go on, which is really, really weird. And then that appeal was granted to Michael Flynn. And the Judge Sullivan was ordered to dismiss the case because the prosecutors who are supposed to be prosecuting Flynn say, actually, we don't have the case we thought we did. We may have not given up exculpatory evidence when we were supposed to. And the conviction is wrong. So we want to stop prosecuting it and have it dismissed. Now, Flynn had pled guilty to lying to the FBI. Upon an internal review, the prosecutor said he shouldn't have even been questioned by the FBI. That was wrong. Now let me go with the Model Rules Professional Conduct, American Bar Association. Okay, Model Rules of Professional Conduct, Table of Contents. Yes, fine. Here is... Stupid fly. Fly's after me. I need help. Counselor, advocate. Public service. Legal services. Integrity of the profession. Is it this one? No. I have to find it. I'm not a prosecutor, so this is the... one I have to find real quick. Special responsibilities of a prosecutor, Rule 3.8. This is important. I know you guys love reading the model rules. The prosecutor in a criminal case shall refrain from prosecuting a charge that the prosecutor knows is not supported by probable cause. Make reasonable efforts to assure that the accused has been advised the right to and the procedure for obtaining counsel, blah, blah. Not seek to obtain from unrepresented accused a waiver of important pretrial rights. Make timely disclosure on the defense of all evidence or information known to the prosecutor that tends to negate the guilt of the accused or mitigates the offense, and in connection with sentencing, disclose to the defense and the tribunal all unprivileged mitigating information known to the prosecutor, except when the prosecutor is relieved of his responsibility by a protective order of the tribunal. not subpoena a lawyer in a grand jury or other criminal proceeding to present evidence about a past or present client, blah, blah, blah. Here we go. Here's another one. When a prosecutor knows of new, credible, and material evidence creating a reasonable likelihood that a convicted defendant did not commit an offense of which the defendant was convicted, the prosecutor shall promptly disclose that evidence to an appropriate court or authority, and if the conviction was obtained in the prosecutor's jurisdiction, promptly disclose that evidence to the defendant unless a court authorizes delay, and undertake further investigation or make reasonable efforts to cause an investigation to determine whether the defendant was convicted of an offense that the defendant did not commit. When a prosecutor knows of clear and convincing evidence establishing that a defendant in the prosecutor's jurisdiction was convicted of an offense that the defendant did not commit, the prosecutor shall seek to remedy the conviction. Are we noticing a pattern here? Are we noticing a pattern of responsibilities of the prosecutor here? The prosecutors in this case, one, found that they violated this rule. 2, now believe that the charge that they're prosecuting is not supported by probable cause. 3, they have new, credible, and material evidence creating a likelihood that a convicted defendant did not commit an offense. They've done all this. This is all in the FBI notes that were disclosed or uncovered or whatever. And they found out that Flynn should not have been prosecuted. So the prosecutor has an ethical obligation to do what the prosecutor is doing. And when a prosecutor does that, when a prosecutor says, actually, judge, we don't have a case, the judge should not, at that point, decide, I think you need to go ahead with the criminal case. That's silly. That is absolutely silly. So here we go. A federal judge in Washington pushed back Thursday against an appeals court decision. Oh yeah, so the appeals court came down 2-1, says that the case should be dismissed immediately. Now, Sullivan, the judge, has sent back to the appeals court a request that the court hear the appeal, rehear the appeal en banc. This is something you do when you have a split in the court, in the appeals court, and you want to take a chance before going to the Supreme Court. You would have an en banc review, and that means that all of the sitting judges of the court will hear the appeal, and they will have a majority vote winner if they choose to do it. You are not entitled to en banc review of a split or unanimous decision. But, you know, depending on the circuit, right? Like if you're in federal court in the Ninth Circuit and you're on the losing end of some liberal issue by a 2-1 split, and you've got 2 of the conservative Ninth Circuit justices, you may ask for an en banc review and hope that there are 5, a majority of liberal justices who will rehear it and then overturn that 2-1 hearing. That's when you would do it. But the appeals court has to accept the en banc review. Will they? It's really rare that they do them. They do them, but it is rare that they do them. However, this is a high-profile case, so they may take it up. And it was split. If it was a 3-0 ruling, it's less likely to have an en banc review. Not en banc review, en banc. It's French. Last month, a divided 3-judge panel of the U.S. Appeals Court for the D.C. Circuit ordered U.S. District Judge Emmett Sullivan of the District of Columbia to dismiss the case at the Justice Department's request, despite Flynn's past admissions that he lied to the FBI about his contacts with the Russian ambassador to the U.S. Writing for the 2-1 panel, Judge Naomi Rayo, the latest Trump appointee to the D.C. Circuit, concluded that Sullivan had overstepped in taking up a review of the Justice Department's decision to drop the case. Yes, of course he has. In a 30-page court filing, Sullivan's lawyers on Thursday asked the full D.C. Circuit to take up the Flynn case and effectively erase the panel's split decision. Sullivan, represented by the prominent Washington lawyer Beth Wilkinson, argued the D.C. Circuit had prematurely intervened in the prosecution before the judge ruled on the Justice Department's motion to dismiss the case. The panel's decision threatens to turn ordinary judicial process upside down. It is the district court's job to consider and rule on pending motions, even ones that seem straightforward, Wilkinson wrote. She added that the D.C. Circuit, if called upon, reviews those decisions. It does not preempt them. So here's Beth Wilkinson with the full Karen going on. And what they're arguing, they're not even arguing that the case shouldn't be dismissed. This is such a colossal waste of resources that I can't get over it. This should actually bother just about everybody. They're arguing that Judge Sullivan should get to rule on this when he rules on the motion. Judge Sullivan's trying to extend, for some reason, ruling on the motion. Now, logic would dictate that Sullivan is trying to not rule on the motion in the way that Flynn and the government want to rule. Sullivan is scrambling for something else. Give me some backup. Help me deny the motion and continue the prosecution of the case. Can I appoint a new prosecutor? That's what logic would dictate, because the alternative is that Sullivan is arguing to just wait until he's ready to dismiss the case and then dismiss the case. But that's a moot argument, right? If you're going to dismiss the case in 30 days, why not do it now? Well, I should get to wait the 30 days. Let's spend hundreds of thousands of taxpayer dollars having an appeals court and an en banc review, and then probably a Supreme Court ruling on whether or not I should wait until my time is up to rule on the motion. Okay. But the reality is, of course, it should be dismissed. Of course. In any other case at all, that's criminal case, where the prosecutor says, we don't want to do it. We don't want to prosecute this person. And the defense says, I don't want to be prosecuted. The judge should immediately go, cool, gone, go to lunch, going home early, I'm jerking off under my robes. That's what should happen. Because why are we subjecting a private citizen to the legal process if the government doesn't want to prosecute them? Why are we doing that? It's only because of the political, high-profile nature of this case that we have this. Just think about this. A guy in your town gets interrogated by the police after a raid on his house. And he admits, yeah, you know, I was doing some meth or whatever. I was doing some meth and I was injecting heroin into my balls. And then they go and the prosecutor's like, okay, well, we've got a confession. We've got a confession there. Great. But then the prosecutor gets the test results back. And they find out that the meth wasn't meth. The meth was cane sugar mixed with Himalayan salt. Okay? And they found out that the injections weren't heroin. It was saline with food coloring. I don't know. I'm just making shit up. And they go, oh, wait. They weren't actually in possession of any unlawful substance. The evidence shows that they weren't in possession of an unlawful substance. But they confessed that they were after 9 hours of interrogation, they said, oh, yeah, I was. But there was nothing unlawful there. So then the prosecutor runs down. The judge has found the guy guilty. He's got a sentencing hearing in 2 weeks. And then the prosecutor runs there. I need cheese because they're fat. And they get to the judge's office and they say, Judge, we got to dismiss this case. I just found some evidence. And it says that they couldn't have done what they said because what we found wasn't meth or heroin. It was Himalayan salt and cane sugar and then saline with food coloring. It's not illegal to have those, and injecting them into your balls isn't illegal either, nor is smoking them. Not advised, but not illegal. We've got to drop this case. The judge should immediately and would immediately dismiss the case. Well, we have a confession. I know they have a confession, but they couldn't have confessed to the crime. They had to make a misstatement under oath. Maybe they were wrong, but if they were wrong, they're still wrong. They don't have it. And we know they don't have it. To put them in prison would be unjust. And if they ever found out that we found out that it was wrong, we would get sued into oblivion. So of course the judge would say, yeah, this case is dismissed. The verdict is vacated and the confession is rescinded. That's what should happen. That's what would happen in any other case. With any honest prosecutor. It's the prosecutor that's the problem in these cases. Let me be very clear. There are lots of cases where people give false confessions and get convicted. But that's not because the prosecutor says we shouldn't prosecute this guy. That's because the prosecutor says, I don't care if we're wrong, we're still going to prosecute them, and then they end up winning. Or getting a plea agreement or whatever. That's where that happens. That's not the judge. The judge who gets that, judge doesn't care. Like, judge goes, okay, so we don't have a case? Well, why are we here? Dismiss it. I want to go play golf or whatever. All right. You can't intend to purchase or possess is really difficult to prove. But that's not, and that's not what they were charged with, right? Bad Vibe says, with concealed carry and face masks in Oregon, an issue arose about it's a felony to conceal carry while wearing a mask. It is frustrating. Oregon is forcing businesses to enforce masks in businesses and threatening OSHA on employees and employers. You know my opinion on masks. I am opposed to the enforcement of wearing masks. However, with that said, someone sent me a very lovely gift, and I want to address it real quick. So this is from Megan, and I won't read all of it, but basically they've been watching the show since the Vic Mignogna thing, and they made me some masks, some reusable, washable masks, and these are pretty cool. Here we go. It's got the Imperial Aquila on the mask, and they made them extra large because of my nose, but they go on like this. So I now am Bane, and I have a mask. So thank you for that. You're obviously of the upper class, and you will be destroyed in the revolution. But anyway, so yes, thank you so much for the masks. They are really cool. And I didn't have any, and I'm probably going to be, traveling, and I might need them. So I do really appreciate that. That was fantastic. They're made. It's probably hard to see on camera, but they're in the style of a faded flag with like blood stains on it. So they've got kind of a gradient of color going across. So very cool. But yeah, I don't know the conflict of laws on conceal and carry plus mandatory face masks. I don't know how that's going to work out. Some lawyers are going to make a lot of money if anybody gets prosecuted for that. They'll make a lot of money figuring that out. Okay. So the DC Circuit will likely now ask Flynn's lawyers and perhaps the Justice Department too to respond to the petition from Sullivan. Presumably, they will say, we don't want an en banc review. That's a waste of time. Any order by the full DC Circuit to rehear the case would void the panel decision. Rather than readily dismiss the Flynn case, Sullivan appointed a former judge, John Gleeson, to oppose the Justice Department's move to drop the case and address whether contempt proceedings were warranted against Flynn. For what? For what? Gleeson, now a partner at the law firm Debevoise and Plimpton, said Sullivan should proceed with sentencing Flynn on his guilty plea. Well, you hired him to say that. Of course he said that. You hired him to not just you hired him to oppose their motion. So of course he said that that's what you should do. Sullivan had also set a July 16th hearing on the Justice Department's bid to drop the Flynn case, but he canceled the proceeding after the DC Circuit panel ordered him to dismiss the prosecution. So this is going to be a fun thing for Sullivan to do. So he had a July 16th hearing. He was ordered to drop the case. He's not going to drop the case, but he's also canceled his hearing. So now, if they determine that he should have had the hearing, he will then have to reschedule it months and months and months out, which is great. Good job. In that panel ruling, Rao and Sullivan's inquiry into the unusual retreat from the prosecution was not... Rao said Sullivan's inquiry into the unusual retreat from the prosecution was not warranted. To begin with, she wrote, Flynn agrees with the government's motion to dismiss, and there's been no allegation that the motion reflects prosecutorial harassment. Again, I have to just go ahead and point out that our criminal procedure system is set to protect defendants. Flynn is the defendant. He's entitled to the deference in this case. And it's burdensome on him. So he should be removed from the case the moment the government doesn't want him there. Go away, fly. Oh. All right. The ruling was widely lambasted as an overreach that restricts the power of courts to question the executive branch. What power should a court have to question the executive branch in a prosecution? Prosecutors cannot dismiss a case on their own. They need permission, leave of the court according to federal rules. Yeah, fantastic. It should be granted immediately. The panel's decision is plainly wrong, and the en banc Court of Appeals will almost certainly reverse it if the case reaches that stage, Georgetown law professor Marty Letterman said in a post on the blog Just Security. But it now stands as the law of the DC Circuit, and everyone who cares about the state of the federal court should take notice. J. Michael Lutig, a prominent former conservative federal appeals he is a federal appeals? Good writing. This is law.com, the National Law Journal. Fucking dummies. Asserted that the DC Circuit had answered the wrong question, improperly framing the dispute in the view of the potential harm on the government, which did not bring the appeal rather than the alleged harm on Flynn. Knowingly or not, the Court of Appeals simply appears to have bungled perhaps the most consequential political constitution case in recent memory, Ludig wrote in an op-ed at the New York Times. He called the panel decision grievously wrong and ill-reasoned. Still, he said the court reached the result that almost certainly will be required by law. Did you hear that? Did you hear that? The court is wrong and ill-reasoned, but it got it right. In 2017, Flynn agreed to cooperate with the Russia investigation as part of a plea deal, which he admitted to lying to the FBI about his phone calls with the Russian ambassador to the U.S. in the build-up to Trump's inauguration. In recent months, Flynn waged a campaign to back out of the plea deal. Just weeks ago, the Justice Department asked Sullivan to dismiss the case. The Justice Department's move to drop the Flynn case, combined with Sullivan's reluctance to dismiss the prosecution, has set up an extraordinary clash between the courts and the executive branch. It has raised novel questions about the scope of a judge's authority to review decisions made in the course of criminal prosecution, and fueled fresh scrutiny of U.S. Attorney General William Barr intervening in case to the benefit of Trump allies. Look. It doesn't matter. I can't say this enough. If Trump called up Barr and said, William, I want you to stop this case against Flynn. He's a good guy. I want you to stop it. Doesn't need this. If it doesn't matter. If you think Trump is corrupt, you must impeach him on the corruption. Because the rights of a private citizen to not be unreasonably brought before a government tribunal when the government itself admits there is no case trumps, for lack of a better word, any impropriety for the purposes of the defendant. If you think everybody else did everything wrong and that they should have prosecuted Flynn, great. Flynn is innocent until proven guilty. He's not actually, he's kind of in this limbo stage right now because he's adjudicated guilty based on a plea agreement that he is now withdrawing. So he wasn't proven guilty. He said he was guilty to get a deal. Now he says that that was all incorrect. And people do this with frequency. But again, we have to get to the point here. The case against Flynn needs to be dismissed. If there's impropriety in the prosecution's actions, you then need to go after them. That's where the problem is. The private citizen can't have any sort of issue to do with that. There's nothing. Flynn can't be a bad prosecutor, and Flynn can't have caused the prosecution to break the rules or even alleged to break the rules. Flynn can only say, my plea was extracted incorrectly and I want it reversed. And the judge ultimately is going to have to do that because the government agrees. Okay. The Justice Department's moved to, the government has, quote, the government has engaged in highly irregular conduct to benefit a political ally of the president. The facts of this case overcome the presumption of regularity, Gleason wrote in his 82-page amicus brief. The court should therefore deny the government's motion to dismiss, adjudicate any remaining motions, and then sentence the defendant. Justice Department's move to abandon the case was a, quote, gross abuse of prosecutorial power, Gleason said. Now remember, Gleason was hired by Sullivan to make this argument. The appeals court rejected it. Rayo was joined by Judge Karen LeCraft Henderson, who did not offer any individual view in the panel ruling. When the case is argued, however, Henderson expressed support for the idea that Sullivan could be allowed to hold a hearing to weigh whether or not to dismiss the Flynn prosecution. Judge Robert Wilkins, writing in dissent, called Rayo's decision a trailblazing result. It is a, quote, it is a great irony that in finding the district court to have exceeded its jurisdiction, this court so grievously oversteps its own, he wrote. So, there you go. There you go. That's the Flynn case. My thoughts on it. I don't care about Michael Flynn. I don't care if Trump intervened. If he did, impeach him. Impeach him. I don't care. Do it. You did it before, do it again. See how it works. From a criminal justice standpoint, if the prosecution decides that they've improperly prosecuted someone, and the defense agrees, which of course they're going to agree, then the judge, the neutral arbiter of the law, should say, I don't have an opinion. Because it's not my fucking job to have an opinion about whether or not this person needs to be prosecuted. That's the prosecution's job. And if they don't want to bring the case, who am I? Do you know how many people every day do not have a case brought before a judge by a prosecutor? Everybody who doesn't. Insane. Insane. Mithrin Emmer says, District Attorney, Judge, we got to drop the case. No evidence. Judge, nah, fam. Bring that guilty mofo in here so he gets a fair trial. Seems legit. Yeah. Yeah. Judge, his guilty plea was coerced. It was coerced by the feds under some threats, and they withheld evidence that said he was innocent. So, no. Yeah, he should still be prosecuted. Wait, what? It was coerced. We know it was coerced. They say it's coerced. We say it's coerced. No. Bring him in here. It's fine. Good God. So there is that mess. Now, let me briefly address... I don't think we're going to get to the full thing on this. I was debating doing this as a full show. And I didn't... I wanted to throw in the other stuff, but then I ended up ranting so much about the other stuff. Let me get this worked out. Where is it? There we go. Okay. What? Oh, here we go. All right. We'll take a look at it, though. Real quick, I want to address this one right away from Automata. I like the whole angle of considering perjury for attempting to withdraw a guilty plea. That seems like a harmless precedent to hand to the government. Oh, yeah. Yeah. That would just be great. Cause yeah, again, well, they kind of tried this. Well, you did say this under oath, and they're like, yeah, but I was coerced, or they're blah, 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 all these problems. And sometimes they don't let them withdraw a guilty plea. In this case, the both parties agree. Of course you should let them withdraw it if both parties agree. All right. So this is the Randazza Legal Group. As they have a brilliant letterhead here. And they are representing the defendants, Paul Michael Ayer et al. It's the defendant's opposition to motion for issuance of preliminary injunction. I hope you caught all that. So here's the gist of this document. This is 15 pages plus some exhibits. We're not going to go through all of them. Factual background, legal standard. No injunction should issue because Patreon is not likely to prevail in the merits. The defendants are not bound by the purported amendment. Defendants may bring their claims, including two not covered by the purported amendment. Defendants' claims are arbitrable. Patreon is not damaged by arbitrating the claims. I mean, kind of, not legally damaged. Patreon is bound by California law as to all defendants, and the balance of harms favors defendants. So that's the gist of it. Let's take a breeze through all of this. And the reason I wanted to do, Patreon filed this lawsuit, and this is the response to their motion for a preliminary injunction. So their preliminary injunction request says these guys' arbitration should be stopped by this court and they should be enjoined from arbitrating this case. And then, they are now saying, no, that's not correct. You cannot stop us from arbitrating it. So that's what's going on here. And I wanted to give you this side of it because I think this side is the morally and ethically correct side of the issue. I'm not saying that is the legally correct side of the issue. That this is such a weird sort of case, as I was saying earlier, that I don't have the expertise or the knowledge at hand to go ahead and tell you what should happen here. But I want to read you the factual background that the Randazza Group lays out here because this is really well put together and it's a good explanation of what is actually happening with the dates that it happened so you can judge for yourself. And not all the dates are in favor of the defendants here. So I want to point that out too. Not all of the dates are in favor of the defendants. And so, we're going to look at this objectively, but I think that this is the correct position. I don't know legally what they will rule. All right. Patreon Inc. demands all claims to be arbitrated on an individual basis. It made its own rules and put up hurdles in the hopes that users would be discouraged from trying to seek justice due to its insistence on private arbitration. And this is true. Patreon's terms of service up until January 1st, basically, said that you need to arbitrate all claims individually. You cannot group them, no class action arbitrations or anything like that, and you must arbitrate them. You cannot sue us until you have to arbitrate it. And then we'll see what happens. Now, when 100 users do exactly what Patreon made them do, Patreon says the rules have changed and it isn't beholden to the set of rules in place when the dispute arose. It is. The requested preliminary injunction should not issue. So they have a little footnote here. Undersigned counsel is in the process of being retained by the named defendants. Although counsel is specifically appearing on behalf of the defendants identified in the notice of appearance, these arguments should apply equally to all defendants. Those defendants should not be prejudiced merely because they did not have sufficient time to engage undersigned counsel personally. All right. So he's still in the process of getting retention letters from all of the 100 people. Factual background. Prior to January 1st, 2020, defendants used Patreon's platform and supported various creators, including comedian Owen Benjamin Smith. Defendant used the Patreon platform as a patron, meaning under Patreon's terms of use that defendants are people, quote, who join a creator's membership on Patreon and pay a monthly membership fee to support the creator. Defendants had a direct contractual relationship with Mr. Smith, as is acknowledged on Patreon's site. Quote, membership is a relationship between you, the content creator, and your most engaged fans or patrons. So what they're trying to establish here is that every person via Patreon has an independent contractual relationship with the creator. Now, the reason that they do this is because if you have a contract with Patreon rather than the creator, then you could force Patreon to make the creator perform the promises that you're paying for, right? So if I say I'm going to do a naked trampoline video at $3,000 on Patreon, and then I get to $3,000 on Patreon and don't deliver on the video, you would in theory be able to sue Patreon for specific performance of making me do a naked trampoline video. They don't want that. They want you to sue me, not them. They want to be removed from this. They just want to be the link between creator and patron to allow them to have their agreement, just facilitate the process of it. That's the goal of Patreon. On October 9th, 2019, Patreon removed Mr. Smith from Patreon due to alleged violations of Patreon's community guidelines, with only vague explanations as its reasoning. So, of course, like everything else, they cut Owen Benjamin and they didn't say why. They just said violations of community guidelines. Defendants could no longer support and access Mr. Smith's account despite fully abiding by the terms of use themselves. So suddenly we now have Patreon making it impossible for the person who was paying Owen Benjamin to access the material that Owen Benjamin was contractually obligated to provide to them through their own private contractual relationship. I'm a patron of Owen Benjamin. He said that if I paid at this level, I get these things, I should get them. Now, when I want to go get them, Patreon is preventing me from doing this. So now we have tortious interference is a general sort of theory here, right? They are improperly preventing you from the execution of a contract that they know exists. Of course, Patreon knows that you have the contract with the creator. It's all done on their platform. All of the terms are laid out on their platform, and presumably, when they review the platform for the violation of the terms of use, they would notice whatever they had. So, and of course, the underlying idea is that there was no violation of the terms of use certainly not by the patrons, but also by the content creator. That's the unspoken words here. All right. As of October 9th, 2019, the date defendants were injured, the operable terms of use permitted a claim on this basis. But they could not file suit nor proceed as a class. In fact, they could not even proceed directly to arbitration. Instead, the dispute resolution clause mandated pre-arbitration negotiations. And by the way, this would be upheld in court. If you have a binding arbitration clause and you tried to sue Patreon, they would dismiss it and say, go to arbitration. You have a binding arbitration clause. Why would we be doing this? You both agreed to this. They would dismiss it and you'd have to bring the arbitration. And then having a mandated pre-arbitration negotiation, you could try and bring the arbitration. You could try and file it, and the arbitrators would likely tell you to go do your mandated pre-arbitration negotiations. That's not an unconscionable clause of a contract. Go have the negotiations. If the negotiations break down, come on back. It's fine. Be fine then. Stating, quote, if a dispute does not arise out of these terms or related to your use of Patreon, if a dispute does arise out of these terms or related to your use of Patreon, and it cannot be resolved after you talk with us, then it must be resolved by arbitration. There you go. Arbitration clause. There's a negotiation clause in there. then you go ahead to arbitration. They can maybe defeat this with by saying that this isn't a mandated negotiation. But, you know, might as well. They didn't try to defeat it, so they wouldn't bother with that argument. Backout says, naked trampoline video will happen. If not, my lawyer, Mr. Beard, will be in touch with you. I'll just threaten to show him the video. He'll back off real quick. Acting in good faith and abiding by these terms, defendants attempted to talk to Patreon. On November 12th, 2019, counsel for defendants in the arbitration contacted Patreon in an effort to resolve defendants' dispute. This dispute included, but was not limited to, a claim of intentional interference in contractual relations due to Patreon's wrongful termination of the account of a creator whom defendants supported. Defendants and Patreon were unable to resolve the dispute via direct discussions on December 4th, 2019. Defendants repeatedly stated an intention to move forward with arbitration if the dispute was not resolved through direct negotiations. Closely following the discussions on December 4th, 2019, the defendants' withdrawal of their settlement offer on December 16th, 2019, Patreon purported to amend its terms of use specifically to preclude from being brought in arbitration claims related to the termination of another user's account, i.e. intentional interference with contractual relations, and only such claims that defendants had raised with Patreon in the required pre-arbitration negotiation. So let's go back through this real quick with a summary. Okay? They go to negotiations and they say, you forced us to have these negotiations. Here's what we want you to do. Whatever their settlement offer was, which is probably put Owen Benjamin back on the platform. Because that resolves all the dispute, right? We want Owen Benjamin on Patreon. He's not on there. Put him back on. Oh, suddenly all our claims are fixed. Great. If you don't do that, we will take you to arbitration. They say, nope, we're not putting him back on the platform. Too bad. So then, okay, we had our talk. They give it some time, 12 days. 12 days, you're not going to do it? Still, are you sure? Want to rethink that? No? Okay, so they withdraw their settlement offer. Then Patreon goes in and amends its terms of service and says that you cannot bring an arbitration for tortious interference of someone else being kicked off. Think about that. You're going to make us arbitrate these claims? Okay, we'll go to arbitration. No, you can't now. Can't do that. We're going to change the contract that you've been under this entire time. On December 20th, 2019, a mere 4 days after rejecting defendant's last settlement offer, Patreon purported to enact an amendment to its terms of use relating to the following matters. 1, precluding users from bringing claims against Patreon for suspending or terminating another person's account. They actually can't do this. This is really questionable. We'll put it that way. You can't bring a legal cause of action against us for tortious interference. That's what they're saying. You can't do it. Can't do it. So yeah. Which aims to bar any of claimants' patrons from exercising their due legal rights in connection with the termination of claimant's account, stating, quote, you may not bring a claim against us for suspending or terminating another person's account, and you agree you will not bring such a claim. If you try to bring such a claim, you are responsible for the damages caused, including attorney's fees and costs. This is, to me, this is a flat out unconscionable provision of a contract. You cannot sue us for an intentional act that causes you harm. I'm sorry. Excuse me? I can't? Okay. And then B, removing the protections of the consumer protection laws and the protections of the JAMS consumer arbitration minimum standards, which claimant enjoyed under the terms of use, stating, quote, this clause does not limit either party's ability to file an action in a court with jurisdiction to seek injunctive or other equitable relief for disputes. Do you see what Patreon, like, I can't stress enough what Patreon did here. Patreon changed their terms of service to specifically do what they're doing now. And you don't get to negotiate those changes. Like, they just changed them and, you use the service, so therefore you accepted. We sent you an email. We sent you an email with this giant terms of service. Didn't you fucking read it? Quote, this clause does not limit either party's ability to file an action in a court with jurisdiction to seek injunctive or other equitable relief for disputes. To enforce this dispute resolution clause, including your agreement not to assert claims related to the suspension or termination of another person's account. Again, they specifically wrote it about this. About this. In any such action, the court, rather than an arbitrator, must decide whether such a claim is arbitrable, and then must decide whether the party is entitled to the requested injunctive or other equitable relief. This is wild because under the JAMS rules, if I'm not mistaken, the arbitrator has the sole jurisdiction to determine whether or not claims are arbitrable. Arbitrable. So you bring the arbitration, and then they can say it doesn't belong here. They can file a motion to dismiss the arbitration just like they could in a court. This belongs in court because it's outside the terms of use. That's done by the arbitrator, not by a court. As discussed below, this amendment was unconscionable, lacked sufficient notice, contained material misstatements and omissions, and was not agreed to by defendants. Patreon asserted in the terms of use that the purported amendment was effective on and after December 20th for new users and on January 1st for existing users. So they gave you a whopping 10 days. Patreon lied when it claimed that defendants were given notice of the amendment prior to its effective date. In fact, defendants may not have been given such notice at all. See Exhibit 1. Let me see if I can... This fly. Oh my God. I hate it. I'm going to kill it. Let's see what they have here for Exhibit 1. I want to see what that is. Let me make sure there's no docs information here. Okay, here we go. So this exhibit is a declaration of Alex Shepard, who is an associate or something. He's another lawyer at Randazzo Legal Group. I'm an attorney for Randazzo Legal Group. Upon information and belief, 21 of the defendants never received timely notice of the purported amendment, and 14 of the defendants never received defective notice after they filed their arbitration demands in 2020. Upon information and belief, the remaining 37 defendants received the defective notice from Patreon prior to filing their arbitration demands. I don't know if I can express how much I hate flies. Whew. Okay, so that's that. And again, we're not going to go through this whole document tonight, but I mainly just want to get through the intro here. Okay, the purported notice was misleading. It stated that Patreon had updated the terms of use to clarify the dispute resolution process and the legal rights of patrons when a creator they support is removed for violating our guidelines. But of course, that's not what it did, right? It didn't clarify it. It redefined them entirely. The purported amendment did not clarify any rights. It simply sought to extinguish those rights. Defendants had no opportunity to negotiate or opt out of the purported amendment. In short, Patreon set up the dispute resolution process, and upon being notified of a dispute, Patreon unilaterally tried to create a sham contract that would invalidate the stated claim. January 3rd, 2020, claimant initiated arbitration proceedings against Patreon in accordance with the provisions of the contract at issue. The JAMS streamlined rules and the JAMS consumer minimum standards, including by paying the requisite consumer arbitration fees, submitting a demand for arbitration to JAMS, and serving Patreon with the demand. Notably, the dispute resolution clause in both versions of the terms of use contain the following pertinent statements, among others. This arbitration must be administered by JAMS under the JAMS streamlined arbitration. Patreon follows the, quote, JAMS policy on consumer arbitrations pursuant to pre-dispute clauses minimum standards of procedural fairness for all arbitrations done under these terms. If any portion of these terms do not follow that standard, that portion is severed from these terms. JAMS agreed to administer the arbitrations without further postponements or delays as set forth in JAMS General Counsel Sherry Eisner's letter of February 3rd, 2020, see Exhibit 3. JAMS letter noted that the terms provide for arbitration pursuant to JAMS streamlined rules and procedures, and specifically cited Rule 8b, deeming that Patreon should address its challenges to the arbitrability of claims with the arbitrator once appointed. The JAMS, yeah. See, that's the other thing, right? Rule 8b. This is what I was talking about under the JAMS rules. Patreon should address its challenges to arbitrability of the claims with the arbitrator once the arbitrator is appointed. You have to ask them. The JAMS letter further stated, accordingly, JAMS will proceed with the administration of these matters upon receipt of the balance of the filing fees, and Patreon may raise its objections with the arbitrators once they are appointed. Patreon has to pay the filing fees. That's what this is about. If 100 people pay $250 to file their arbitration on the Owen Benjamin side, that's a total of what? 25 grand? Right? I'm not a calculator. 100 times 250, $25,000. Now, Patreon has to do, let's see. Patreon has to pay a significantly higher amount. And it's a lot. And under California law, they have to pay it within like 30 days. I don't know how much it is per person, but it's like maybe 20 grand. So they're looking at like $2 million in arbitration fees. And that's an issue here, right? Is that Owen Benjamin's patrons were able to do this for an aggregate of $25,000, democratized over 100 people. Patreon now has to fork up $2 million in cash to fight back. And yes, someone says, sounds like they deserve it. Yes, they demanded it. They demanded it. Of course they demanded it. Because they didn't write their terms of service thinking that this would happen. They wrote the terms of service to say that, look, someone who's giving a patron $5, or a Patreon creator might sue us, and we want to bring them to arbitration where we'll have a say in who the arbitrators are, and they'll have to pay $250, and then we'll pay the rest. Sure, that's fine, but it's going to be one person coming after us, right? And then we're going to crush them. And then we'll maybe get them to pay our arbitration fees and all that stuff. They weren't thinking, oh, wait, we have a bunch of other people who are under these terms of use, and they have to do the same thing. They didn't separate out their arbitration requirements or anything like that prior. Okay, so JAMS issued a second letter on March 12th stating that JAMS would not issue a blanket stay for numerous separate arbitrations. Specifically, the March 12th JAMS letter stated, Patreon's terms of use state that arbitrations, quote, may only take place on an individual basis, and no grouping of parties is allowed. So Patreon didn't want people to band together and do a class action, right? Because again, it discourages people. If they're not able to band together, you can fight them separately, and it makes them less likely that they're going to bring the claim. Like, oh man, I pay a creator 20 bucks a month and I think that Patreon screwed me over, do I want to pay $250 and hire an attorney to go through arbitration? Or do I just want to do something else? Now, if you've got 1,000 people all banding together, sure, it looks a little bit better. Oh, maybe we all have the same problem. We can all bring this and we can all get our claim back in a class action. Maybe. But they discouraged that. Patreon asked for this. More importantly, they demanded it, and you had no ability to negotiate against it. Let's see. In light of this language and in light of claimants' objections to the request for a temporary stay of the Patreon claims, JAMS will not issue a blanket stay of the Patreon claims. Any request for a stay must be raised with the arbitrator in each individual case. Patreon had to abide by its own dispute resolution clauses and California law, but Patreon did not want to abide by either. Therefore, Patreon filed the instant suit for declaratory relief on 5 causes. 1. The defendants are subject to the purported amendment. 2. That defendants' arbitration claims are prohibited. 3. That defendants' arbitration claims are not arbitrable. 4. That the arbitration claims have damaged and will continue to damage Patreon. And 5. That the claims of the non-California defendants are not governed by California Code of Civil Procedure. Patreon seeks a preliminary injunction asserting a likelihood of success on all 5 cases or causes. For the reasons set forth below, no such injunction is warranted. And that's where we're going to stop on this for the evening. Because again, that's the story. That's the story. And here's the funny thing. You know, Patreon doesn't want to do this because they're required to pay those fees. And it's going to cost them a fortune. And they want to argue that that shouldn't apply to them because it's unfair, even though they put the unfair clause in front of all of us. And they just didn't think through their business model. And unfortunately, sometimes you just don't think through your business model. And you get sued for something that you never thought would be an issue. But it is. But it is an issue. Of course it's an issue. And so then, yeah, they tried to change the rules that they picked, giving their customers no say in that rule change. Because you know how terms of use go. We're changing the terms of use. How many of you have ever clicked no? Like, well, what am I going to do about it? Right? You can't line it out and send it back to them. I only accept under these conditions. Uh-oh. I'll be right back, guys. 1 second. Woo! Hey guys, sorry about that. Had a bat signal. All taken care of. All taken care of. All right. Where were we? So yeah, the long and short is you don't get to really challenge those rule changes. If you want to keep using the service, you accept the rule change. If you even see it. Sometimes companies have gotten into this new habit of they change the rule and they send you an email or a letter in the mail or something, and that meant you accepted it. Well, no, it doesn't. Doesn't mean anything. You may not have seen it. It may have gone to your spam folder. It could just be sitting in your inbox. Or it may not have come to you at all. Maybe they have outdated information. But despite disfavoring adhesion contracts, courts have held them up. They've held them up as valid. And I think that's nonsense. But this is a great case about that because now Patreon is arguing that it doesn't want to be held to its own adhesion contract. It wants to be able to change the adhesion contract at any time to its benefit and just force that upon other people. But great. Great. But so here's the other rub though. In doing this, in taking these actions, they may be exposing themselves to further arbitration claims on new issues. So that's funny too. And we'll have to see how that goes for them. But I think that's the problem that they've got is that none of these companies are used to the idea that there are people dedicated enough to say this is bullshit and fight back. Like Patreon never thought that this would happen. It never once entered their mind that, oh my God, 100 people are gonna file a claim. What if it was 1,000? If it was 10,000? I mean, if 1,000 people did it, Patreon maybe goes out of business tomorrow. That's how much money this is. That's how dire this is for Patreon. 100 people, $2 million is a massive amount. Remember, Patreon processes a lot of money, but they only take 5% of most of it. So their margin, their income is 5% of what they process, and their profit is a percentage of that. Having 2 million, 20 million, 200 million if you get 10,000 people. Like imagine if Belle Delphine got canceled and all of the dudes got together and went after Patreon. That's a lot of people. And that's a lot of fees. So this is an interesting new sort of weapon that we have in the fight against these stupid contracts. The problem with it is, of course, is that they can just write out their arbitration provisions. Although that may ultimately be a win for us. May ultimately be a win for the consumer. So we'll have to see. We'll have to see how it goes. But this is pretty interesting in general. Like I said, the procedure on it is crazy. Looking forward to reading through what the Randazzo legal group found for the legal standard and what Patreon has for the legal standard, and figuring out exactly, trying to find out who's right. I don't think there is a right in this. I think the judge will determine it, and that's going to be a pretty big, impactful decision. And I really hope it goes the way of the defendants, because I think it's funnier that way. So, where is Drexel? He's probably at his house. What kind of question is that? Okay, let's do super chats and then we'll wrap up the show, and then we'll probably move over to Twitch for a watch party in just a little bit. All right, Crusader Saracen says, geez, I wish America was on the verge of a Christian theocracy. I don't, but I know a lot of people. I'd probably prefer it to what's going on right now, but I also wouldn't prefer it at all. Shill Ian's GoFundMe? Ian who? Mercenary X says, the problem with Sullivan is that the man has secrets and he knows that Michael Flynn knows where all the metaphorical bodies are buried. I'm telling you here and now, the corruption that Flynn knows about is worse than anyone knows. They are desperate. I mean, I guess. Night of Hope X says, hey, look at it this way. You'll be making a hell of a lot more money as a lawyer when the state can compel prosecutors to bring cases against random people. In fact, how about we just suspend regular society and just have court for the rest of our lives, eh? Yep. Oh, Ian from Crypto Fashion? Go do that one. I don't have it pulled up. So, but yeah, support him. Go do it. Let's see. Mercenary X says, Nick, please do not tempt the internet, especially the weirdos. Better out there, and that's me being nice. At this point, you're just asking for people on the Chans and the farms who are Slaneshi cultists to come after you. Mind you, Slanesh cultists are better than Ron. Wait, what? What do you mean don't tempt them? Ethical Dilemma says, haha, Patreon deserves everything it brought on itself. The moment it started censoring and banning people for bullshit reasons, they should be held accountable. All they had to do was be the go-between. Instead, they had to get woke. So let's hope more comes. Mario Carter 13 says, thanks, Supreme Court. Very cool. Hashtag abolish California. Okay. Weirdo with a cello says, have to clean up a roach problem. A day-long project at best. Ugh. Saved a bunch of your streams just for the occasion. Please send Exterminatus. God, I hate roaches. I hate it. Hate them. Sinning in Chief says, Mark Randazza on your stream to talk Patreon when? And I addressed this earlier. I'm hoping to have Mark on the stream next week. I don't know that we'll be able to address this particular suit. It's up to him. If he wants to talk about it, it's great. I'll ask him. But if he says, no, I'm not going to press him to talk about an ongoing case. Gawker's Death Rattle says, got bumped from Discord. Replacement for new Project 2 yet? I have a subscribe star. It's supposed to be up. It's supposed to be up. It's subscribestar/Rekieta Law. Here, I'll put it in the chat. But someone said it wasn't working. I don't know why. It's under review still. But the review doesn't mean you can't sign up for it. So I don't know what I have to do. But I think, I mean, it should be running. So that's a way to do it. Then replace the MP2 link in the description. Yeah, I should do that. I forgot that it defaults and has that there. You get accustomed to things defaulting in. Mexican Man and Cheese says, Rambo Last Blood is on Amazon. Did you watch party it yet? No, that's a good candidate for tonight. The Adamisk says, Seminole Nation sex crime writes itself. Come on. No. DCV Titan says, Nick, question. Was there not a video of Monica getting her fan to hug Ron? Or did I hallucinate that? Yeah, there's a video of that. Can't sub till you're approved. It says right at the top. It doesn't say that to me. It says, your profile is under review. However, due to an extremely high volume of recently submitted profiles, the approval will take longer than usual until your profile is approved. Uploading/posting capabilities are limited to text and photos only. Don't tell me what it says. I can read. I mean, it might say that on yours, but I can't see that. I can only see what it shows me. So I'll work on getting it approved. Mexican Man and Cheese says, oh wait, no, DCV, no, Ryoji Mata says the district attorney stated that she was specifically going after Trump when she took office, which is an ethics violation. She's a political attorney, not an unbiased one. And attorneys are not unbiased. Attorneys are biased. That's the whole idea. So anyone who thinks that attorneys are unbiased is wrong. They are specifically biased. Prosecutors are biased towards the state and against the people. They don't typically acknowledge that, but they are. They are. That's why they have to have rules to compel them to act decently when they're supposed to. Mario Carter 13 says, unsolicited display of subpoenas. My privates. Jason of the Great Awakening says, Mr. Peacock claimed on stream if Trump manages to pull a second round of COVID bucks, that he'd be declared emperor or something. Seems likely. It apparently seems likely, but the limit is something like 40 grand. I don't know. But everything's being shut back down, so hopefully they'll do something for people. Mario Carter 13 says, defense and prosecution, I consent. Judge, well, I don't. Jason of the Great Awakening says, does this Flynn case literally demonstrate poisoning the well can itself damage the judicial system beyond repair? Yeah. I mean, in a way. Automata says, I like the whole angle of considering perjury for attempting to withdraw a guilty plea. Seems like a harmless precedent to hand to the government. Angry Hydralisk says, don't mind me, I'm just testing something with a new account. Also, thanks for streaming today, Nick. Your hair is great. Please don't cut it. Dust says, one of the many reasons I like winter. F flies? Yes. AGK says, tell that fly that it has fulfilled its contract and that its payment is in the mail. Thanks, my guy. Rude. Bad Vibe says, does Flycoon sound like Jeff Goldblum if you listen close enough? Everything sounds like Jeff Goldblum if you listen close enough. Cringe Lord says, okay, hot take. If Patreon tosses out their own terms of service, could that be grounds for a counterclaim to toss the entire terms of service and thus toss Patreon's arbitrary escape clause in the process? No, because they have a severability clause in there that says if it's not enforceable, the rest of the terms still are, to the extent that they are. So it would have to first attempt to be severed, but severability clauses aren't infallible, and maybe. Mr. Schwagen says trust and safety board member equals goodbye company. Yeah. Yes. Yep. I see what you're saying. Yeah, they're when you have a trust and safety board, say goodbye to your company. Good. DCV Titan says, could I get that video from you? Having a private conversation over in the comments on the DA Talks to Emish and Ron Victoria video and would like it. I don't have it handy. It's on the Kiwi farm somewhere. Crumbs in my left mutton chop? I don't. Okay. I wish I had crumbs in my mouth. Let's see. Mercenary X says, the naked trampoline. Are you trying to make the weirdos come out of the woodwork? Oh, mind you, I'll take the Slanesh cultists over anything out of Hollywood or Ron Toye's group. Less degenerate than those two. Oh, okay, that's what you were talking about. Making them come out. Crusader Saracen says, but in A Few Good Men, didn't Kevin Bacon say he represents the government of the U.S. without passion or prejudice? Also, the UCMJ is effing terrible. That is all. Crusader Saracen, Patreon. We notified you of our change of terms. Arnold, it's all bullshit. So there you go. There you go. All right, guys. That's the stream for today. And we are going to go over to, let's get the outro playing. We're going to go over to Patreon and Twitch in just a bit, and we will be doing a movie watch. I'm not exactly sure what movie yet. Just come over and find out. It's all going to be fun. Happy Hydralist says, I'm no longer angry. I am happy Hydralist now. Okay. And Derpy Jew sent $1. Thank you for that. You guys really want to watch the original Terminator? Really? Okay. Let's do it. That's the one. Original Terminator is the movie tonight. So come watch it. Come watch it. And we may do a trashy movie after it. We'll see. We'll see. All right, guys. I'll see you over there. Peace. Peace.
She makes sure that he has the time and the place to provide for them there. So pour out an art bag about more of love rug. The spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter as we hear Lost Planning tonight. From the white shores of Nan to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we are now. Oh, the guests are all planet folk from Doug T to Drexel. They bring their perspective and spice to the